Scene 28 ended with delimitation, defeated and women's reservation inoperative. Both waiting on one thing, that is this scene. This scene is that thing. What happened? This is scene number 42, census 2027 and the caste count, the data that unlocks everything. So what happened? Why census 2027? And why the caste count? And what is the data point that unlocks everything? On 30th April 2025, the Cabinet Committee on Political Affairs decided that caste enumeration would be included in the forthcoming population census. The first full caste census since 1931. The colonial era last instance in 1931. But in 2011, socio-economic and caste census was a separate exercise whose caste data was never released on the grounds of quality. So, in 2025, June, the government notified the Census of India 2027, but comes to the reference date midnight of 1st March 2027 for the country. And 1st October 2026 for snowbound areas of Ladakh, Jammu and Kashmir, Himachal Pradesh, and Uttarakhand. So it will be the first digital census. It will be the first digital census. First digital census with a self enumeration option. Conducted as always under the Census Act 1948. Comes to the census being a union subject under entry 69 of list 1. So this is all about census, that is census 2027, and that going to be caste count, and this is first since after 1931 and etc. So comes to the point, single point, that is why this single administrative notification is constitutionally enormous. Why? Why? It opens three doors at once. What are the three doors? Door number one, that is delimitation. Door number one, that is delimitation. The articles 82 and 170 freeze, and the 106th amendment's women's reservation are both key to the first census taken after 2026. So census 2027 is that census. So implementation of women's reservation is key for this census, because after this census only women's reservation bill is going to be into effect. Women's reservation. So after the 131st amendment's defeat in scene 28, this is the only remaining constitutional route to both seat reallocation and the operationalization of women's reservation, which is precisely why the census timing is itself politics. So what is the door number one here? Delimitation. For women's reservation operationalization and delimitation, both for this door one entry. And then comes to the door two. What is the door two? subclassification. What is subclassification? In state of Punjab versus Devinder Singh, August 2024, a seven-judge bench held that states may subclassify scheduled castes for reservation purposes, but only on the basis of empirical data demonstrating differential backwardness, not political convenience. So, Telangana became the first state to operationalize this in April 2025, dividing its SC list into three groups. So, a national caste enumeration supplies exactly the empirical foundation that Devendra Singh demands and will simultaneously reignite the Indra Sahani 50% ceiling debate because fresh caste data will generate fresh claims. So comes to the door 3. What is the door 3? That is federal arithmetic. The same census that enables delimitation re-triggers the South states' anxiety of scene 28. Now with real numbers instead of projections. So carry the balanced closing caution because UPSC will expect it. What is that UPSC will expect? Enumeration cuts both ways. What are the both ways? Counted caste enables evidence based targeted social justice policy and the argument that you cannot remedy what you refuse to measure. But critics warn that a decennial official caste count risks hardening the very identities the constitution's transformative vision hoped would dissolve. What UPSC will expect it from this? The same census that enables delimitation re-triggers the southern states anxiety of scene number 28 and now with real numbers and instead of projections because carrying the census after carrying the census the real numbers will project it. So carry the balanced closing caution because UPSC will expect it, that is enumeration cuts both ways. Counted caste enables evidence, counted caste enables based evidence, and targeted social justice policy. The argument that you cannot remedy what you refuse to measure. But critics warn that a decennial official caste count risks hardening the very identities the Constitution transformative vision hoped would dissolve. So, that tension, what is that tension? Measurement as remedy versus measurement as entrenchment is the essay grade closing thought. And the status discipline, one more time. What is that status discipline? One more time. As of the revision, the census is notified and scheduled, not conducted. Every consequence in this scene is prospective. So comes to the tension part. Measurement as remedy versus measurement as entrenchment of identities of the constitution hoped would dissolve. What is the measurement as remedy? You cannot fix with you refuse to measure. You cannot fix what you refuse to measure. So comes to the answer writing part. The decision to enumerate caste in census 2027 has implications extending far beyond data collection. Discuss. Answer. Answer states the April 2025 decision and June 2025 notification with both reference dates, then traces the three doors delimitation and women's reservation under the post 2026 census trigger, then subclassification under Devender Singh's empirical data requirement with the Telangana example, and then federal seat share question, and closes the measurement versus entrenchment tension, presenting the census as scheduled and its consequences as contingent. So let us summarize: one notification, three constitutional consequences like seats, subquotas, and federal bargain, all switched on by a single reference date, that is 1st March 2027. So scene 28 told you what failed. This scene tells you what everyone is now waiting for. That is the empirical data, digital census, census cost count. The date is 1st March 2027. So this is all about census 2027. And next chapter, next scene 43, that is the DPDP Act meets the RTI. When two derived rights collide. What is the DPDP Act and what is the RTI and what rights collide, etc. We are going to discuss. This is the extent of governance half of GS to transparency and accountability and part of one's fundamental rights scenes. So what is this actually? Here two rights, each judicially derived from the fundamental rights and set against each other by a single statute. So the framework first in one breath. What is the framework here? The right to know is not written into the constitution, but the Supreme Court derived it from Article 19, Clause 1, Subclause A in State of UP versus Rajnarayan in 1975 case. And the RTI Act 2005 operationalized it. So the right to privacy is not written in either Puttaswamy. The right to privacy is also not written in either. So Puttaswamy 2017 case derived it from Article 21. So RTI is not in the constitution itself. Then right to privacy also did not in the constitution itself. Those two are derived from different cases by Supreme Court. So for 2 decades after the implementation of RTI, operationalization of RTI, Act balanced them internally. Right to privacy as well as right to information act. Comes to the section 8 class 1 subclass J of RTI Act, exempted personal information from disclosure unless a larger public interest justified it. So with the famous proviso that information which cannot be denied to parliament or a state legislature shall not be denied to any citizen. Now the collision. What is the collision here? The Digital Personal Data Protection Act 2023, that is called as DPDP Act. This is India's first comprehensive data protection law. Digital Personal Data Protection Act 2023 is India's first comprehensive data protection law, itself a direct legislative response to Puttaswamy case. It contains in section 44.3, in section 44 clause 3, an amendment to the very RTI provision. What is that provision? A public interest override. A public interest override. And the parliament proviso go, leaving personal information exempt from disclosure simpliciter. And the act moved from paper to operation in this cycle. The DPDP rules were notified in November 2025, setting the statutes phased implementation in motion, then consent requirements, obligations on data fiduciaries, then a data protection board. The transparency community's objection is concrete, not abstract. What is that? The diluted section 8 class 1 subclass J of RTI Act could shield exactly the disclosures that made RTI an accountability weapon. Public servant assets, qualifications, service records, and over 100 of opposition MPs formally sought the amendment's repeal. The government's defense is equally concrete. What is the defense of government? The amendment merely aligns the RTI with the privacy right Puttaswamy declared fundamental. So add one institutional design observation that ties this scene to the chapter's running theme. I am going to do this. The Data Protection Board, the Act's adjudicating guardian, is appointed entirely by the central government, and the Act carries broad exemptions for the state. So the who guards the guardian? Question of scene 33 returns here in data governance costume. So this is not transparency versus secrecy. This Article 19 clause 1 subclause is derived right against Article 21's derived right, with Parliament having picked a side by statute. Privacy is a genuine fundamental right, and RTI has genuinely been misused for harassment. But a democracy default must remain that information about public power is public, and any narrowing of the default demands a justification the citizen can test, which a blanket exemption by design cannot offer. So what is the institutional design flaw here? The data protection boards appointed entirely by the center with broad state exemptions. So since 33's guardian question is data in data governance costume. So comes to the answer writing. The Digital Personal Data Protection Act 2023 has been criticized as strengthening one fundamental right at the cost of another. Critically examine with reference to the right to information. Comes to the answer writing. First of all, answer traces both rights to their derivation. from Rajanarayan and Puttaswamy case respectively states precisely what Section 44 Clause 3 changes in Section 8 Clause 1 Subclause J in the RTI Act, presents the shielded disclosures concern on the privacy alignment defense even-handedly, then adds the data protection board's independent question and closes with the harmonization argument. What is that argument? Harmonization. The pre-amendment, Section 8, Clause 1, Subclause J already balanced the two rights, case by case, and replacing a calibrated balance with a categorical exemption is a loss of constitutional craftsmanship, whatever one's views of the outcome. Calibrated case by case, balance replaced by a categorical exemption. Privacy is real, RTI misuse is real, but information about public power defaults to public. So let us summarize. Know the two derivations, the one amended section, the November 2025 operationalization, and the two-sided argument, and file this scene as your governance and a transparency anchor for the cycle, the counterweight to a part otherwise dominated by courts and parliament. So here we discussed so far two sections. One is two two acts and two fundamental rights, RTI and DPDP Act. Right to know under 19 article is and 21 article right to privacy. We discussed so far for one right against another. So this is all about DPDP Act and RTI. So then we are moving to next scene, that is the vice presidency changes hands, resignation, vacancy, vacancy, and the constitution's quiet machinery. This is extends chapter 6, scene 12 parliament and quietly completes scene 26 and 37. So comes to this vice presidency changes hands. As actually what happened on 21st July 2025, the first day, the first day of the monsoon session, Vice President Jagdeep Dhankar resigned under Article 67A, 67 Class A, citing health with immediate effect. Place the precedent exactly. Vice presidents have left office early before, but always en route to presidency till now. B.V. Giri resigned in 1969 to contest the presidential election, and R. Venkatraman and Shankar Dayal Sharma vacated on being elected president. So Dhankar was the first midterm resignation of the office unconnected to a presidential bid. A genuinely novel constitutional movement here. The election followed on 9th September 2025. C.P. Radhakrishnan, the then governor of Maharashtra, defeated the opposition's candidate, former Supreme Court Judge B. Sudarshan Reddy, by 452 votes to 300, and was sworn in as India's 15th vice president. Actually, this happened. And complete the office's eventful arc with the first that preceded the resignation. In December 2024, Opposition MPs moved the first ever notice for removal of sitting vice president under Article 61, Clause B, directed at Chairman Dhankar over alleged partisanship in the House. And the deputy chairman rejected it on grounds including the failure to give the 14 days notice Article 67, Clause B requires. So note the removal design while you are here, because it is a classic prelims to mains bridge. A vice president is removed by a Rajya Sabha resolution passed by an effective majority agreed to by the Lok Sabha. No grounds are specified in the constitution and no formal impeachment style inquiry is prescribed as far as a vice president's removal is concerned. So making it procedurally the lightest removal mechanism among the high constitutional offices. So within 8 months, the same office produced the first ever removal notice against its occupant and the first ever midterm resignation unconnected to a presidential bid. A reminder that even the constitution's quietest offices can supply a cycle worth of it first. So the constitution provides no acting vice president. Contrast Article 65, which expressly makes the vice president act as president. But vice president contrasts act no acting vice president. When the vice presidency itself falls vacant, the office simply stays empty rather than acting vice president. No appointment. And the deputy chairman presides over the Rajya Sabha in the interim. Article 68, Article 68, Clause 2. Article 68, Clause 2 requires the election to be held as soon as possible after the vacancy. No fixed 6 months outer limit, unlike a presidential vacancy. So, the person elected serves full 5-year term, not the remainder of the predecessors. And the electoral college is the classic comparison point here. Both houses of parliament, including nominated members, by proportional representation with single transferable vote, with no participation by state legislatures, unlike the presidential election under Article 54. Because the vice president's real constitutional life is as ex officio chairman of the Rajya Sabha under Article 64, an office internal to parliament. The then vice president, whose super parliament and nuclear missile remarks you met in scene 26, and the then Rajya Sabha chairman, whose NJAC crossroads framing you met in scene 37, are the same office and the same man, and this scene is why both scenes say then. So the transition also gives you a quieter analytical observation. What is that observation? An office whose occupant had become the most vocal constitutional critic of the judiciary changed hands mid confrontation. A reminder that the executive judiciary dynamics, these part traces are shaped by individuals as much as institutions. So comes to the answer writing part. This topic leans prelims, but a mains question could come dressed as institutional analysis. So comes to the question. The Vice President of India is a constitutional bridge between the executive and the legislature. Discuss. With reference to recent developments. Comes to the answer writing. Answer, first of all, sets out Articles 30, 63 and 68 compactly. Then the dual character of the office. Then the 2025 resignation and its distinctness from the Giri Venkatraman Sharma precedents, then the no acting VP and full term rules, then and the electoral college contrast with the president, precision over length, then throughout. This is the answer writing regarding this. Three facts here. What are the three facts? Article 67A resignation in July 2025 and why it was a first. The vacancy mechanics no acting VP. Election as soon as possible. Full fresh term. And the electoral college contrasts with president. 90 seconds of material permanently examinable. So this is regarding vice presidents. Then comes to the next scene, that is Ladakh, the other half of the 2019 Act. This is extends chapter 7 scene 13A supplement union territories and complete scene 32. Comes to the scene 32, told you what the 2019 Reorganization Act left unfinished in Jammu and Kashmir. The scenes tell you here what it left unfinished in the other union territory it created. And the contrast between the two is analytical payoff. What is that analytical payoff? The structural fact first. What is the structural fact here? The 2019 Act gave J&K, that is Jammu and Kashmir, a legislative assembly and gave Ladakh without legislative assembly. So Ladakh is governed by Lieutenant Governor with only the Ladakh Autonomous Hill Development Councils of Leh and Kargil as elected local bodies. Ladakh is governed by a Lieutenant Governor with only the Ladakh Autonomous Hill Development Councils of Leh and Kargil. These only are the elected local bodies. So a region that before 2019 elected members to a state assembly now elects no legislature at all. No legislature at all. So out of the democratic deficit grew a sustained movement led by the Leh Apex Body and the Kargil Democratic Alliance. These two bodies from communities historically divided but united by four demands. What are the four demands of Leh Apex Body and Kargil Democratic Alliances? First demand, statehood and inclusion in the sixth schedule under Article 244. A dedicated public service commission with job safeguards and separate Lok Sabha states for Leh and Kargil. These are the demands. Under Article 244, which currently applies only to tribal areas of Assam, Meghalaya, Tripura, and Mizoram. So comes to the sixth schedule, demand rests Ladakh's overwhelmingly scheduled tribe population. The basis on which the National Commission for Scheduled Tribes itself commented inclusion back in 2019. So the sequence of this cycle precisely dated. Talks ran through high-powered committee under the Minister of State for Home. In 2025, the center notified partial concessions by regulation 85% job reservation for Ladakh domiciles, one-third reservation for women in the hill councils, and official language recognition. Then the rupture. What rupture? Why rupture? On 24th September 2025, a protest in Leh turned violent. Four protesters were killed in police firing. A BJP office was torched. curfew allowed, and climate activist Sonam Wangchuk, the movement's most visible face, was detained under the National Security Act and lodged in Jodhpur jail. Comes to the repair and notice timing. On 14th March 2026, the center revoked Wangchuk's detention after 169 days and just ahead of Supreme Court hearing on the habeas corpus challenge to it, expressly to foster peace, stability, and mutual trust for dialogue. So a fresh round of talks followed on 22nd May 2026, with the center reportedly preferring protections by regulation under Article 240, that is presidential legislation for union territories over sixth schedule inclusion, and the latest beat as of this revision in late June 2026, Wangchuk began a fresh indefinite fast in Delhi, saying the dialogue's conclusions were never formally recorded and the promises remain unfulfilled. So present this like so much else in this part as live and unresolved. So three constitutional threats, each independently examinable. What are they? First, asymmetric federalism's floor comes to the J&K has an assembly but not statehood. Then Ladakh has neither. The two halves of the 129 1 2019 Act each carrying its own unfulfilled promise. And together the sharpest available illustration how reorganization under Articles 3 and Article 4 can subtract democratic depth, not just redraw lines. This is unsymmetric federalism's floor. This is the first thing. And then second, the instrument question. What is the instrument here? Sixth scheduled status is a constitutional guarantee. Hard to dilute. Why? Then Article 240 regulations are executive origin instruments, revocable by the same route that made them. And the movement's insistence on the former over the latter is at bottom. An argument about the difference between a right and concession. Exactly the missionary versus guarantee distinction seen 27 trained you on. Then comes to the third one, preventive detention and dissent. What is the preventive detention and dissent? An NSA, National Security Act, detention of the protest leader revoked on the eve of judicial scrutiny sits squarely in the Article 22. Debate about preventive detentions compatibly with democratic protest, a thread you can connect to the fundamental rights block whenever a question invites it. So this is regarding second half. So comes to the summarized part. Know the asymmetry. What is the asymmetry? Assembly versus none. The four demands, the sixth schedule versus Article 240 distinction, and the date sequence from the September 2025 violence to the fast underway as the revision. The scene 32 and the scene are one question waiting to be asked. What is that question? What does the union owe the territories it creates? What does the union owe the territories it creates? Then we are moving to next scene, that is Manipur. Manipur, Article 356 runs its full course. This is extends chapter 5 scene 11 federalism and gives the emergency provisions their only live anchor in this cycle. Every scene in this part so far has tested some institution's power at its edges. But this scene tests the Constitution's most drastic federal instrument. And unlike almost everything else in Part 3, it is not pending, not sub judice, not awaiting committee. It ran its complete course inside your revision window. What is this? And what is the reason behind including Manipur in this revision list? So imposition, parliamentary extension, and revocation. That completeness is precisely what makes it examinable. You can narrate the entire life cycle of Article 356 with real dates instead of textbook hypotheticals. So the sequence here is precisely, I'm going to tell you, that is, on 9th February 2025, Chief Minister N. Biren Singh resigned a day before his government was to face a floor test. And after nearly 2 years of ethnic violence between the Metis and Kuki-Jo communities that had claimed over 250 lives and displaced roughly 60,000 people since May 2023. So, the then governor declared the scheduled assembly session null and void. When the ruling party could not agree on a successor, President's rule was imposed on 13th February 2025 under Article 356. On the governor's report of a breakdown of constitutional machinery, the 11th time in Manipur's history, counting its union territory years till now. So note the design detail that matters most. What is the detail? What is the design and what are the details here? The assembly was not dissolved but kept in suspended animation. On 13th August 2025, Parliament approved a 6-month extension by statutory resolution, as Article 356(3) requires. And then on 4 February 2026, the President revoked the proclamation under Article 356, Clause 2, which, remember, needs no parliamentary approval for revocation. Continuation need approval. Revocation no need of a parliament approval. And a new government was sworn in the same week under Yamnam Kemchan Singh, drawn from the very assembly that had spent a year in suspension, with two deputy chief ministers chosen deliberately across the ethnic divide. Nemcha Kipken, Manipur's first woman deputy chief minister from the Kuki-Jo community, and the second from the Naga People's Front. So now run this through the framework you carry from scene 11, the SR Bommai test. What is the SR Bommai's test? Was this Bommai complaint use of Article 356? On its face, yes, and say so. A chief minister resigning ahead of floor test, no alternative climate, an assembly unable even to meet, and a genuine prolonged land order collapse. This is far closer to Bommai's justiciable grounds than the politically motivated dismissals the judgment was written against it. So, but a high scoring answer does not stop at complaints. It names the two harder questions the episodes leave behind. What are the questions? First, the suspended animation question. Suspended animation question. Keeping the assembly alive rather than dissolving it preserved democratic continuity. Democratic continuity. The same house ultimately produced the new government. But it also meant that for nearly a year, an elected legislature existed simply did not function, which sits uneasily beside Article 174's requirement that a house meet at least once every 6 months. Comes to second, the deeper Article 355 question. First question, what? Suspended animation. And the second question, what? Article 355. What is the Article 355 question? The union's duty to protect states against internal disturbances. The union's duty. What is the union's duty? To protect states against internal disturbances had arguably been engaged since May 2023. So was February 2025 an application of the emergency provisions, that is Article 356, that is President's rule, or an admission of the 2 year delay, or an admission of the 2 year delay? That question, not the mechanics, is where the analytical marks lie. Comes to the answer writing part. The imposition and revocation of President's rule in Manipur illustrates both the utility and the limitations of Article 356. Discuss. What is the answer? How to write the answer? Answer traces the full dated sequence: resignation, imposition, extension, and revocation regarding Manipur. Then tests it against the Bombay framework and concedes its facial validity, and then complicates the picture with suspended animation paradox and the Article 355, that is delay critic, and finally closes on the constitutional design inside the episode offers. What is that? Article 356 proved capable of pausing a crisis, but only politics, not the proclamation, could produce the inclusive government that ended it. So one complete Article 356 cycle here, four dates to know, that is 9th and 13th February 2025 and 13 August 2025 and 4th February 2026. One design choice. What is that choice? Suspended animation, not dissolution of the house. And one closing line. What is that here? Worth memorizing. What is the one line here? Closing line. The emergency provisions can suspend a government, but they cannot manufacture a consensus. The emergency provisions can suspend a government, but they cannot manufacture a consensus. That is why you have to use any emergency provisions answer. Then, then we are moving to the next scene. That is the speaker's clock. That is speaker's clock. The 10th schedules Telangana test. This is extends scene 12 from Parliament. Then same gatekeeper disease as scenes 30-38 in a different organ with using of speaker. So scene 38 gave you removal motion dying at the president officer's gate. This scene gives you the same constitutional disease in a different organ. That is the anti-defection law and a speaker's discretion over when and whether to decide at all. So together with scenes 30 and 38, it completes a pattern UPSC can ask about directly. What is that questions UPSC asks directly? Across removal of judges and disqualification of defectors alike, the the Constitution's enforcement mechanisms run through presiding officers whose inaction, whose inaction no one can easily compare. So that is the speaker and that is the chairman. So the facts in sequence we are going to learn, you going to know, that is after the 2023 the Telangana Assembly elections, 10 MLAs elected on the BRS ticket defected to the ruling Congress from March April 2024 onward. So disqualification petitions under paragraph 2 clause 1 subclause A of the 10th schedule were filed almost immediately and then sat. The matter travelled up. A single judge of the High Court directed the Speaker to fix a hearing schedule. A division bench set that aside, holding no timeline could be imposed on the Speaker. And on 31st July 2025, in Padi Kaushik Reddy versus State of Telangana, a Supreme Court bench of CJI B.R. Gawai and Justice A.G. Masai restored the pressure. The court's reasoning rests on two precedents you already carry, that is, Kihito Holohan 1992 and Subhas Desai 2023 both established that the Speaker, when deciding disqualification petitions, act as a tribunal, and a tribunal enjoys no constitutional immunity from judicial review under Article 226 and 227 and 136. On that footing, the court directed the Speaker to decide the 10 petitions within the 3 months. Directed further that any MLA attempting to protract the proceedings would face an adverse inference. And delivered the line you should quote. What is that quote delivered here? The court cannot allow a situation of operation successful but patient died. Disqualification petitions kept pending for the life of assembly, letting defectors reap the full benefit of the delay. That is the statement given by court. Now the ending here is, and this is the analytical heart of the scene. What is that? Because the ending shows the limit of even Supreme Court clerk. The 3 month deadline lapsed. The 3 month deadline lapsed. In November 2025, the court issued a contempt notice to the Speaker, calling the non-compliance the grossest kind of contempt. What followed was compliance in form, and critics argue defiance in substance. The Speaker decided the petitions in staggered batches from December 2025 to 11th March 2026. The final two orders arriving one day before the next Supreme Court hearing and dismissed all 10, holding that the petitions had produced no concrete documentary evidence of voluntary defection. Treating media footage of the MLAs campaigning alongside the Chief Minister as merely hearsay. So set that evidentiary standard against Ravi S. Nayak 1994, which you know from the scene 12, voluntarily giving up membership. Voluntarily giving up membership requires no formal resignation and can be inferred from conduct. Voluntary giving up membership requires no formal resignation and can be inferred from conduct. The BRS has announced a challenge before the High Court, so status discipline. As always, the disqualification question itself remains live, even as the delay question has been answered in the defector's favor by the calendar. So, why this scene matters beyond the Telangana? It exposes the 10th schedule's structural flaw in its purest recorded form. Purest recorded form. The 52nd Amendment entrusted adjudication. The 52nd Amendment entrusted adjudication to the Speaker precisely for speed. 4 decades later, the Speaker's clock has become the defection strategy itself. A member who defects on one day, on day one, and disqualified in year 5 has lost nothing. And notice the doctrinal tension the Supreme Court itself is caught in. It can declare the Speaker a tribunal, set deadlines, even threaten contempt, but it stopped short of deciding the disqualification itself, because that adjudication is constitutionally the Speaker's. The standing reform proposals write themselves from the tension. An independent judiciary, an independent adjudicatory tribunal headed by a retired judge, the direction to the 170th Law Commission report and repeated judicial obiter have pointed or at a minimum a constitutional fixed decision period with a deeming consequence. So here we learn, we have to learn structural flaw in 52nd constitutional amendment, that is defection law. So comes to the answer writing part, the anti-defection law fails not in its substance but in enforcement. Discuss in the light of recent developments. Answer states that in the schedule's design and its speaker-centric enforcement, then traces the Telangana sequence with dates petitions in July 2024, then the July 2025 3-month direction and the contempt notice, the staggered dismissal ending in March 2026, deploys the operation successful patient diet framing, contrasts the speaker's evidentiary standard with Ravi Nayak case, connects with the gatekeeper pattern to the Judges Inquiry Act admission stages from scene 38, and closes with the independent tribunal reform argument. An adjudicator who belongs to the ruling majority cannot credibly police defections that benefit the ruling majority. That is the thing here. So here, know the case name, two dates that frame it: 31st July 2025 and 11th March 2026. The Tribunal not immune doctrine from Kyoto and Subhash Desai and the pattern it completes the scene 3038. Three constitutional enforcement mechanism, three presiding officer gates, and a growing case that the gates themselves are the problem. That is the thing you are learning from this particular scene. Then we are moving to the next scene, that is the bulldozer judgment, punishment without trial demolished. Then this is the extends chapter 4, scene number 10, basic structure, the rule of law, and pairs deliberately with scene number 40. Comes to the scene number 40. Scene number 40 gave you a bill that removes ministers and custody rather than conviction. The scene gives you the judgment that had already condemned the same constitutional logic a year earlier in its most physical form. The practice spread across several states of demolishing the homes of persons accused of crimes, with the demolition arriving faster than any court could. What is the judgment here? Directions in the matter of demolition of structures, 13th November 2024, a bench of justices B.R. Gawai and K.V. Vishwanathan. The court's core holding is a single quotable proposition of constitutional first principle. What is that first principle of constitution? The executive cannot become judge and punisher. Demolishing a person's home because they are accused or even convicted of an offense is punishment without a trial, and it violates the separation of powers and the rule of law. The executive cannot become judge and punisher. Demolishing a person's home because they are accused or even convicted of an offense is punishment without a trial, and it violates the separation of powers and rule of law. The court anchored the right in Articles 21's guarantee of shelter and made the collective punishment point that lifts the judgment above the individual case. So a demolition punishes not the accused alone but every family member under the one roof, under that roof, none of whom is accused of anything. Then the remedial architecture issued under Article 142 as Pan India guidelines. And know these operationally because UPSC love testing whether you know what a judgment actually directs. So, no demolition without a prior show cause notice with a minimum of 15 days from service, a personal hearing, and a final order recording reasons, time after the order for the occupant to appeal or vacate, videography on any demolition actually carried out, and the enforcement tooth, which is the genuinely novel part. What is that? Officials who violate these directions face personal liability, restitutions of the demolished property at their own cost. The court was equally careful about what the guidelines do not cover. And a balanced answer says so here. Unauthorized structures on the public land, roads, footpaths, railway lines, water bodies, and demolitions ordered by a court remain outside the framework. The judgment does not protect illegal construction. It protects the legal process. Why the scene? Why this scene ends in the place next to scene 40? The two are argument in two scales. The 130 amendment bill proposes removal from office in 30 days of custody with no judicial finding anywhere in the chain. Like that, Bulldozer justice is imposed loss of home and accusation with no judicial finding anywhere in the chain. The Bulldozer judgment supplies the doctrinal answer to both. What is that? In India's constitutional scheme, adverse consequences of a punitive character require adjudication. The presumption of innocence is not a procedural courtesy, but a structural allocation of power between executive and judicial. If UPSC asks about the 130 amendment, this judgment is your strongest citation against it. If UPSC asks about bulldozer demolition, scene 40 is your evidence that the underlying temptation punishment by executive action. Because separation of powers is not a local aberration but a live constitutional trend. Then comes to the answer writing part. The rule of law requires that punishment followed adjudication, not accusation. Discuss with reference to the Supreme Court's directions on punitive demolitions. Answer states that November 2024 judgment and its separation of powers court sets on the guidelines architecture precisely. Notice, hearing, reasoned order, videography, personal official liability. Then notes the public land and court order exceptions to show balance. Then invokes Article 21's right to shelter and collective punishment dimension, and closes by widening the lens of the custody based removal debate of scene 40. Then the Constitution's answer to popular impatience with slow courts to fix the courts, not to bypass them, because executive has not judge going to be not going to be judge. So one judgment, one principle here. The executive cannot punish. One remedial toolkit under Article 142, one personal liability innovation, and one cross reference to scene 40 that runs two isolated topics into a single essay grade argument about the rule of law under pressure. That is scene number 40, that is custody, 30-day custody minister. And this is the bulldozer judgment punishment without trial demolitions. This is regarding separation of powers. So demolition of structures, anchored Article 21's guarantee of shelter, then pan-Indian guidelines under Article 142, like show cause notice, minimum 15 days from service, then personal hearing, reasoned final order, time to appeal or vacate, videography of any demolition, the novel enforcement tooth, that is personal liability, officials who violates directions restore the demolished property at their own cost. Then balanced a good answer states that unauthorized structures on public lands and court ordered demolitions stay outside the framework. Then pairing 130th amendment removes with no judicial finding. One principle, one execution approach. Then question. This is regarding the bulldozer judgment. Then comes to the next scene, that is places of worship act, secularism's other courtroom. What is the places? What is the places of worship act? And what is the secularism's other courtroom? This is extends chapter 4, scene number 9, salient features. Select secular democratic republican pairs with scene 31, the Waqf case. Scene 31 gave you secularism tested through the regulation of religious property. This scene gives you secularism tested through the freezing of religious history. And unlike Waqf, where the court has already spoken, though an interim order here, the defining feature of a deliberate, sustained judicial pause. What is that sustained judicial pause? Knowing exactly what has been frozen here and why this is the whole scene. Then the statute first in one breath. What is the statute here? The Places of Worship Special Provisions Act 1991 prohibits the conversion of any place of worship and mandates that its religious character be maintained as it stood on by August 1947, with the Ayodhya dispute as its sole excess exception. So, and carry the doctrinal anchor you already have. What is the doctrinal anchor? The Ayodhya Constitution Bench in 2019 described the act. It is considered arbiter. It is considered obiter as a legislative instrument protecting the secular features of the Constitution, the principle of non-retrogression. That comes to the trigger sequence. What is the trigger sequence? Through 2024, district courts began entertaining suits seeking surveys of mosques, and dargahs, Ganwapi in Varanasi, the Shahi Idgah in Mathura, and then in November 2024, a district court survey order the Shahi Jama Masjid in Sambal, which was followed by a violence and deaths. And days later, a suit claiming a temple beneath the Ajmer Dargah. Roughly 18 such suits against about 10 mosques were in motion. So the response came on 12 December 2024. A special bench of then CJI Justice Sanjeev Khanna with Justice P.V. Sanjay Kumar and K.V. Vishwanathan directed that no court in the country shall register any fresh suit of this kind, and no pending suit shall see any effective or interim order, including survey orders, while the Supreme Court examines the act's validity. By February 2025, with fresh petitions multiplying, the CJI's enough is enough remark closed the door on new entrants. So now the two-sided challenge what is here is, and it is genuinely two-sided, present in the way from one direction petitioners challenge act itself, then freezing the position it at an arbitrary colonial era date, they argue extinguishes the judicial remedy of entire communities for historical wrongs, implicating Articles 14, 15, 25, 26, and 29. And the sharper jurisprudential point, the very access to courts the Article 21's right to remedy jurisprudence protects. So, from the other direction, an equally large set of petitions, including political parties and members of parliament, seek the act's strict enforcement, arguing that at the flood of survey suits it precisely the relitigation of history the statute exists to prevent. So, and that the Ayodhya obiter has already located the act within the constitutional secular architecture. The union's counter affidavit remarkably remained unfilled for years. Itself a citable fact about executive retains on the question. As of this revision, the position is the December 2024 freeze holds, and in Feb 2026, a bench led by CJI Suryakant indicated the challenge will be listed for final hearing. What dates to follow? Argued nowhere. Decide nothing. Frozen everywhere. Comes to the framework point that ends marks. This is the mirror image that the Waqf case. In scene 31, the state acted and religious communities invoked rights against the statute. Here, the statute protects the status quo and litigants invoke rights against the protection. Both cases ask the same underlying question from opposite ends. Is secularism in operation a shield of existing religious arrangements or a license to reopen them? And the court's interim method is identical in both. Neither strike nor uphold, but stabilize and take time. Whether the judicial pass is prudence or abdication is itself fair mains debate. The freeze has prevented violence adjacent litigation, but it has also left the constitutionality of the 35-year-old statute formally unresolved while suits accumulate behind the dam. So comes to this summary part. One statute, one frozen date, 15th August 1947, one freeze order, 12th December 2024, a two-directional challenge, and a status of pending final hearing of as of this revision. Pair it with scene 31 in any secularism answer, that is Waqf. and you have the theme covered from both ends. So this is places of worship act, secularism and other courtroom. So the statute 1991 act freezes every place of worship religious character as at 15th August for 1947. And then trigger, what is the trigger? Sambal case. Then 2024 special bench. What said? Then genuinely two directional challenge. What is against the act? An arbitrary colonial era date and for strict enforcement. Then citable facts, what? Union's counter affidavit, etc. Then we are moving to next scene, that is caste behind bars. Article 17's return to the front line. This is extends part 1 equality scenes and gives the parties only Article 17 authority. Every equality development in part 3 so far has been about representation, that is seats, quota, subclassification, etc. But this scene is about equality at its rawest form, raw. The state itself practicing caste discrimination inside institutions wholly controls. What is that? Institutions. And it hands you something rare, a live current judgment squarely applying Article 17, the Constitution's most absolute and least litigated fundamental right. What is this article? Article 17, untouchability. What is the judgment? Sukanya Shanta versus Union of India, 3rd October 2024. A bench led by CJI DAY Chandrachud and register the origin. What is that origin? Because it is itself the story. What is that story? Here, the petition grew from investigative journalism documenting that the state prison manuals, some essentially unrevised since the colonial era, openly allocated prison labor by caste, cooking reserved for so-called higher castes, cleaning and sweeping assigned to castes associated with those occupations outside, and separately stigmatized numbers members of denotified tribes through habitual offender classifications that presumed criminality by birth. The court struck these provisions down across the board, holding that they violate Article 14, Article 15's prohibition of caste discrimination, and Article 70's abolition of untouchability in every form. Article 21's guarantee of dignity, and the class students always forget, that is Article 23, because assigning degrading labor degrading labor by caste is forced labor in constitutional terms. The operative directions all states to revise these their prisons manuals within 3 months, deletion of the caste column and a caste based work allocation from prison registers, and continuing judicial oversight of compliance. The doctrinal payoff stated, so you can quote it in your answers. That is, Article 17 is not a museum piece about a social practice, but a living guarantee that binds the state's own institutions. And discrimination does not become constitutional because its victims are prisoners. The judgment also does something methodologically important for your equality framework. It treats the habitual offender category through the lens of colonial continuity, holding that a classification ban of criminal tribes acts logic cannot survive contact with Articles 14 and Article 15. That is transformative constitutionalism operating exactly as Part 1 described it. The Constitution as break from, not a continuation of inherited social hierarchy. One adjacent equality peg belongs to this scene. What is that? For completeness on the vulnerable sections limb of the syllabus, in January 2025, the Supreme Court dismissed the review petitions against Supreme versus Union of India, its 2023 judgment declining to recognize same-sex marriage. The legal position therefore stands exactly where 2023 left it. No fundamental right to marry has been recognized. And the question of civil unions and marriage equality remains on the court's own reasoning with the legislature. The review's dismissal confirms that on this frontier, unlike digital access in scene 36, the court has chosen institutional restraints over rights expansion, knowing which frontier is moving, which is not itself status precision. So comes to the answer writing. This question we are taking, caste discrimination within state institutions represent the most direct violation of the constitutional vision of equality. Discuss with reference to the Supreme Court judgment on prison manuals. This is the question. Answer should be like this. Answer states that Sukanya Shanta holding with its full 5 article foundation, Article 14, 15, 17, 21, 23, explains the colonial continuity reasoning on habitual offender classifications, then notes the operative directions and the compliance oversight design, then situates the case in the transformative constitutionalism frame part 1 and closes with the implementation caution. The script has started to apply everywhere a stuck down manual provision ends the rule. Not necessarily the practice. The judgment's real test is the prison yard, not the law report. So here one judgment, 5 articles and one deleted caste column, and the cleanest available demonstration that equality courts most radical class. So Article 17 still has work to do inside state's own walls. So you have to remember Sukanya Shanta versus Union of India, then struck down across the board 5 articles 14, 15, 17, 21, 23. And then what are the directions? All states revise prison manuals within 3 months. Caste columns and caste based work allocation deleted from registers. Continuing judicial oversight of compliance. Then doctrine to court. What is the doctrine here? Article 17 is not museum piece. It is a living guarantee binding the state's own institutions, and discrimination does not become constitutional because victims are prisoners. Comes to the adjacent peg, 2025 review petitions against Suprio dismissed, no fundamental right to marry recognized, and civil unions left to the legislatures. Then comes to the 5 article foundation, 14, 15, 17, 21, 23. So this is the caste behind bars. Article 70 is written to the front line, and then we are moving to next scene, that is the Madrasa judgment. What is basic structure here cannot do. What is the Madrasa judgment? This is extends scene chapter 4 scene 10 basic structure and gives the part is article 30 anchor. What is this? Comes to the case. What is the case? Anjum Kadari versus Union of India, 5th November 2024, a 3-judge bench led by CJI DY Chandrachud. The Allahabad High Court struck down the entire Uttar Pradesh Board versus Board of Madrasa Education Act 2024, Madrasa Education Act 2004, holding that a statute creating a board for religious minority education violated secularism as a basic feature of the constitution. The Supreme Court reversed, and its first holding is the one to memorize ordinary legislation cannot be struck down for violating the basic structure directly. The basic structure doctrine policies constitutional amendments under Article 368. A statute can be invalidated only on 2 grounds: lack of legislative competence or violation of Part 3 or any other express constitutional provision. Abstract features like secularism or democracy are too indeterminate to serve freestanding tests or ordinary laws. A challenge invoking secularism must be traced to the specific articles 14, 15, 25, 26, 28, in which the constitution has concretized it. So notice what this does to your scene 10 framework. It draws a clean boundary around Kesavananda's doctrine, mighty against amendments, unavailable against statutes, and it is precisely the kind of doctrinal limits point to the subreddits of real answer from slogan. The second slogan, second holding balances regulation against minority rights, and it is your Article 30 material for this cycle. The court upheld the act is legitimate exercise for the state's power to regulate educational standards in minority institutions, registration, curriculum quality, teacher qualifications, reasoning that Article 30 is right of minorities to establish and administer educational institutions not absolute and does not immense institutions from standards aimed to ensuring students receive a quality education. Regulation that improves the institution without destroying its minority character in constitutional. The one part stuck down. The one part stuck down proves the method. Provisions empowering the board to award higher degrees Kamil and Fazil fell not on secularism grounds, but on the entirely conventional of ground legislative competence since higher education standards belongs to the UGC Act under entry 66 list 1. Look at the architecture here. The sweeping ideological ground rejected, the precise federal ground applied. Exactly the ground by ground discipline scene 31 praised the Waqf interim order. Why this matters across the syllabus? It is a constructive counterpart to scene 90, scene 49. The secularism in invoked to freeze. Here the court refuses to let secularism in the abstract theory insist in the concept live only through specific constitutional text. Together two scenes give you a sophisticated answer to any question on Indian secularism judicial meaning. What is here? It is neither a sword against minority institutions nor abstraction floating free of the articles. It is whatever Article 14, 15, 25, 30 read together and applied provision by provision make it. Comes to the answer part. Can ordinary legislation be invalidated for violating the basic structure of the constitution? Discuss with reference to the recent jurisprudence. Answer should be like this. Answer states the first and foremost. Answer states the Anjum Kadari holding and its reasoning about the doctrine's interdeterminacy as a statutory test. Then contrast the two available grounds. What is the available grounds? Competence and part 3. Legislative competence. And part 3 traces the judgment's own application of them to the Madrasa Act brings on the Article 30 regulation versus autonomy balance. Then closes with the doctrine map. What is that map? Basic structure limits the amending power under Article 368. Part 3 limits the legislative power. Confusing the two levels is not figure but carry category error. So two holdings to state into statements flat. What is that? Statutes fall only for incompetence or part 3 violation. Never for abstract basic structure claims struck down. And minority education institutions cannot be regulated for quality without violating Article 30. One case, the both basic structure chapter, minority rights chapter get their current affairs anchor. So here, Anjum Kadari versus Union of India case. What is that? UP Board of Madrasa Education Act 2004 for violating secularism as basic feature. This is the Allahabad HC struck down the entire UP Board of Madrasa Education Act 2004 for what? Violating secularism as a basic feature. This is the issue. Then what holding? Ordinary legislation cannot be struck down for violating the basic structure directly. This is the important point you have to memorize. Then statute falls on only two grounds. What is the statutes we are going to tell you for struck down? That is lack of legislative competence or violation of part 3 and express provision. Abstract features like secularism, democracy are too indeterminate indeterminate. A secularism challenge must be traced to the specific articles. What are the articles? Article 14, 15 equality, 25, 26, 27, 25, 26, 28. Religion, religion, right to religion, and minority rights. Then what is the holding to here? Article 30 balance the right of minorities to establish and administer institution not absolute. This is also here. Quality regulation. Quality regulation is valid where it improves the institution without destroying minority character. So the act upheld that footing. Struck down part method, the board's power to award Kamil Kamil Fazil degrees fell not on secularism but on conventional ground competence, higher education standards. UGC Act Entry 66, List 1. So secularism neither a sword against minority institutions nor a free floating abstraction. It lives through Article 14, 15, 25 to 30 read provision by provision. So this is the thing. Simple thing is ordinary law cannot struck for violating basic structure directly. Then next scene we are moving to who investigate investigators like the ED legal privileges. This is extends chapter 8 scene 14 that judiciary the scenes 43 is guardian theme and arms your scenes 40 answer. Scenes 44 part critic of the 130th amendment bill rests on one empirical premise. What is that? Bill rests on empirical premise, that is the investigative agencies can be weaponized. This scene supplies the premises evidence file. What is that? The cycles confrontation between the enforcement directorate and the one profession whose independence the justice system cannot function without. That is, what is the trigger? Mid 2025, the ED issued summons to two senior advocates of the Supreme Court, Aravind Datar and Pratap Venugopal, seeking their appearance essentially because they had rendered legal opinions to a client under investigation. They had rendered legal opinions to a client under investigation. The bar's reaction was immediate and institutional. The ED withdrew the summons and issued internal guidelines requiring its directors to prior approval for any such summons. And the Supreme Court took sumo to cognizance of the larger question. What is that larger question? In the same window, the court had also stayed the ED's probe into a Tamil Nadu state liquor corporation with pointed oral observations that the agency was crossing all limits and breaching the federal structure, a quotable data point for the federalism dimensions of the agency overreach here. Since the state entities investigated by a central agency is precisely the anxiety since 46 parties objectional objections articulate here. What is the judgment? Summoning advocates who give legal opinion or represent parties during investigation of cases. 31st October 2025, a three-judge bench of CJI BR Gawai and Justice K. Vinod Chandran and NV Anjaria know the holding in layers. What is the holding here? The core rule, an advocate cannot be summoned by any investigating agency merely for having advised or represented a client. Professional communications are privileged under Section 132 of the Bharatiya Saksha Adhiniyam 2023, that is 2023, and the only exceptions are the statute's own communications furtherance and illegal purpose are facts showing the advocate's own participation in crime rather than opinions. The constitutional anchoring, which is what lifts this into GS2, the court grounded the privilege not in professional courtesy but in the fundamental rights, the client's protection against self-incrimination under Article 20, Clause 3, the right to legal representation flowing from Articles 21 and 22, Clause 1, and the advocate's own Article 19, Clause 1, Subclass G, right to practice the profession. Comes to the operational safeguards, any summons to an advocate under the statutory exceptions requires prior approval for a of a superior officer and remains subjected to judicial law and judicial review. The court deliberately rejected the bar's more elaborate peer review committee proposal in favor of enforceable simple checks and the boundary in-house counsel as salaried employees rather than independent advocates receive only limited protection, a distinction worth one line. Now widen the lens because UPSC will. This judgment is one tile in a larger unresolved mosaic about the ED and the PMLA. The review of Vijay Madanlal Chaudhary, the 2022 judgment that upheld ED's expansive arrest and attachment powers remains pending, and the question of whether PMLA amendments that build those powers could validly travel the money bill route sits before the seven judge reference from Roger Matthew 2019 still unconstituted and undecided as of this revision. So the accountability map reads the agency's powers upheld but under review the procedure of their enactment awaiting a bench, and the court meanwhile build fences around specific abuses advocates privilege here personal liberty in a steady line of bail judgments connecting this the charters running question one more time since 33 asked who selects the election empire, since 43 asked who guards the data guardian, this scene asks who investigates the investigators, and the honest current answer is episodically. The Supreme Court, the Supreme Court, and structurally no one yet comes to the answer rating, but the power of central investigative agencies must be balanced against constitutional rights and the federal structure discussed in the light of recent judicial interventions. Comes to the answer part, what we have to write is start with uses the advocate judgments as its centerpiece, the privilege rule, its fundamental rights anchoring, then approvals plus review safeguards, and add the federalism data point from the state corporation probe, then maps the pending structural questions honestly the Vijay Madanlal review and the money bill reference, cross reference in 40's custody based removal bill and legislative dimensions of the same anxiety, and closes with the institutional design conclusion this entire part has been building. So rights protective judgments are fences, not architecture, and India's agency accountability architecture remains unbuilt here till now. So one judgment 31st October 2025, one rule. What is that rule? No summons for advising, and one constitutional foundation. What is that constitutional foundation? Articles 19(1) G, 20 class 3, 21, 22 class 1, two safeguards. What is that? What are the safeguards? Prior approval, judicial review, and two pending structural questions. What are the two pending structural questions here? The PMLA review, the money bill bench. File it beside scenes 40. Together they are the prosecution power question asked twice. Once of Parliament's bill, once the executive agency. This is all about who investigate investigators. Here we discussed about the ED, two senior advocates, and the PMLA and money bill. So then comes to the closing synthesis. What is the closing synthesis here? Not one scene introduced a principle absent from part 1 and 2. Every current event was an old framework wearing these cycles of cloths. What is this cycles of cloths? So these are, so notice something comes to the one line insert for the parliament framework. The money bill question whether speaker certification and article 110 can be judicially reviewed, and whether statutes like Aadhaar Act and PMLA amending finance acts validly traveled that route. So remains referred to a 7-judge bench by Roger Matthew 2019 and still awaits the constitution and decision of the revision. It is the oldest unanswered structural question about parliament and the court's docket. And the one line acknowledging its pendency shows the examiner map, not just news regarding money, bills. So notice something about every scene in this part. Not one of them introduced in a new constitutional principle you had not already studied in previous parts. Deemed assent tested separation of powers. SIR tested the missionary versus rights distinction. Delimitation tested the amending powers real limits. Justice Verma the collegium debate and the Yadav episode together tested independence versus accountability from three directions: exit, entry, and speech. And the pendency and AI scene added the fourth dimension: accountability for output, the speedy justice itself, and Article 21 entitlement. Waqf tested secularism operative meaning. J&K tested asymmetric federalism and union territory framework. Then CEC appointments case tested the oldest institutional question of all: who guards the guardian? Then rights to trio tested the oldest doctrinal relationship of all from three agencies, three angles. Property owners tested FR DPSP balance where they collide over property. The Uttarakhand UCC tested it where a direct finally becomes land meets rights based resistance. And the digital access judgment tested it where the two work in harmony: digital access and RTI, a directive enlarging a right, then collision, contest and cooperation, the complete grammar of part 3 and part 4 in three cases, and scene 40 to 40 to 45 widened the frame. The 130th Amendment Bill is testing in real time whether constitutional morality can override the presumption of innocence. Basic structures next battlefield possibly decided while you revise. The 16th Finance Commission tested the fiscal half of the federal bargain, and Census 2027 the demographic half. The same southern states anxiety, once in money and once in seats. The DPDP RTA collision tested what happens when a situated statute sees two judicially derived rights, then to know and to privacy, against each other. The vice presidential transition tested the constitution quite continuity machinery, and Ladakh tested half of the 2019 reorganization that the J&K scene left untold. A territory with neither assembly nor safeguards, asking whether asymmetric federalism has a floor. Scene 46 to 50 to complete the grammar. Manipur tested the emergency provisions across a full cycle. The constitution harshest federal instrument used extended and voluntary surrendered. The Telangana defection saga anti-defection tested the 10th schedule and found the same gatekeeper diseases in 30 and 38. Diagnosed the removal process, three mechanisms, three presiding officers, gate one pattern. The Bulldozer judgment stated the principle that seen to 40's bill now tests legislative form. Punishment requires adjudication. The places of worship freeze gave secularism its second courtroom, mirroring Waqf from the opposite direction. Then prison manual judgment put Article 17 back to work inside the state's own institutions. And the review dismissal in the marriage equality matter marked the frontier where the court has chosen restraint. Then Madrasa judgment drew the boundary of the basic structure doctrine itself. Mighty against amendments unavailable against statutes, and balanced Article 30 against the state's power to regulate. And the advocate's privilege judgment asked the chapter's guardian question of the investigators themselves. Every one of them, two is the five questions answered for you. This is exact skill main rewards. The exact skill is three-part script has been built to train. Read the news, name the constitutional principle underneath, and write an answer using the frameworks you already carry. That is the whole of GS2 polity and governance. So compress it into one habit of one habit of mind. That is five questions a parting tool. What are the five questions? Which constitutional principle is involved? Which institution is exercising power? Which competing constitutional value in tension? Which judgment or provision provides the framework? And how would UPSC convert this into a mains question? So this is, again I am repeating, One last thing before we close. And what is that? And it will take 90 seconds. Between now and your mains, new controversies will appear in the newspaper. Things no revision script, including this one, has covered because they have not happened yet. When they do, don't ask which chapter does this belong to. That question makes you filler filer of information, not your filer of information. Ask 5 questions instead. This makes you an analyst. One first question: which constitutional principle is involved? Second question: what institution is exercising power? Third one: which competing constitutional value is in tension with it? Fourth one: which judgment or constitutional provision provides the framework? And the fifth and final one: how would UPSC convert this into mains question? Watch it work on something you already know. Take, for example, let's say take SIR from scene 27. Which principle this here, underlying here? Universal adult franchise. Which institution? Election Commission. Exercising Article 324, read with Section 21, Clause 3. What is the tension here? The integrity of the role against the individual's right not to be wrongly excluded from it. Then which framework? The proportionality test the Supreme Court applied in ADR versus ECI. And the mains question writes itself. Does the machinery serve the right or become its gatekeeper? Then in 15 seconds, and a news item became an answer plan. Every scene in this part was secretly these 5 questions answered for you. From tomorrow, you answer them yourself. If you can do it, you can decode almost any GS to current affair, including the ones that haven't happened yet. That is the skill. Go and build it.